An update for you now on our breaking news out of Manitoba. The Winnipeg man accused of killing 4 women says he did it, but he shouldn't be held criminally responsible. The lawyer for Jeremy Skibicki says his client suffers from mental illness. The surprise news came this morning at a hearing in Winnipeg. The request from defense lawyers prompted the Crown to consent to a judge-alone trial. The case will now hinge on Skibicki's mental capacity and intent in the killings. He was charged with 4 counts of first-degree murder in the deaths of 4 Indigenous women in 2022. Let's bring in Robery Karrass, a criminal defense lawyer, to talk more about this. Robert, thanks very much for joining us today.
My pleasure. Thanks for having me.
A surprise motion today found not declaring that he's not criminally responsible for this. A lot of people questioning that. Not an easy thing to prove, though, is it, in our courts?
Certainly not easy to prove, and they would have to have quite a bit of evidence to suggest that not only is he suffering from a mental disorder and that there's a history of mental disorder, but also that it was affecting his ability to know right from wrong, to understand the nature or quality of his actions, or to know that what he was doing was wrong. So it's really an uphill battle for him.
What will happen? How will this unfold now with that declaration?
So what's really happened here is he was set to start a trial, and it was a trial by jury. They decided that they were going to seek a judge-alone trial, and they needed to bring a motion because otherwise it has to be on consent, and it was not on consent. He admitted that he killed the 4 women in question, the 4 victims here. And so the Crown has basically consented to the matter moving forward by judge alone, meaning no longer using a jury to decide the matter. But the defense has put forward this defense of not criminally responsible based on mental disorder. And so now there's going to be a hearing in front of the judge as to whether or not there is sufficient evidence to show that not only was he suffering from a mental disorder, but that at the time of all 4 of these killings, that he was unable to know right from wrong or appreciate what he was doing. I really don't see how he's going to be able to prove it, but obviously I haven't seen the evidence or heard anything in terms of the defense's case. So it's going to be interesting to see how it unfolds.
And now will both sides bring in their experts to interview him? How is it determined?
So normally what will happen will be that there is an assessment done. It's called an NCR assessment, where a forensic psychiatrist will talk to not only the accused, but also members of his family, people that might know him, and victims. But in this case, the victims have passed, but there are obviously also victims of this individual because he had been abusive towards his spouses and towards ex-girlfriends. So there are people that forensic experts can talk to, and they will develop an opinion. Was this person suffering from a mental disorder, and does he meet the test for NCR? And it oftentimes boils down to a battle of the experts. So the defense will have their expert, the Crown will have their expert, unless they can agree on one expert to be shared. And the judge will hear all the evidence and testimony, and will make a decision.
And why is the jury being excluded then? Why only a judge only?
So juries are very useful when the issue that has to be determined is factual. What are the facts? What does a jury believe happened? But when we're talking about technical arguments, which are mental health arguments and legal arguments, those often have to be explained to a jury who don't have legal training, don't have an understanding of it the way that a judge may, given a judge's experience, legal training, etc. So in cases of NCR and in cases that involve complex legal issues, and mental health defenses are legal issues, oftentimes you'll rely on a judge to make that determination because they're in a better position than a jury to understand the implication and the application of the law to the facts.
Now, what would happen if he is found not criminally responsible there, but he's admitted guilt already? Would that mean an automatic guilt and jail time?
Yes. So he's admitted that he has killed these women. So now the question is not did he do it, but why did he do it? If a judge disagrees with the defense that he was not criminally responsible, finds that the evidence is not sufficient to make that defense out, then he will be convicted of murder. Whether or not it's murder in the first degree or second degree is unclear. I would assume murder in the first degree. and he will be sentenced to, in this case, there are 4 victims, so likely 4 counts of murder in the first degree, resulting in 25 years of parole and eligibility, but a life sentence.
Okay, Robert, thank you very much for your expertise on this. Appreciate it.
My pleasure.
Robery Karrass is a criminal defense lawyer.